There are many cases around, but nothing more important than two of the brothers who spent almost all their life in the prison system. Finally, their conviction of murdering Malik Shahabaz, Malcolm X, Rahimullah alayh, is overturned. And although one of them, in the meantime, have passed away, one of them is joyful. And there are other cases in which everybody is pleading self-defense. We have with us Edward Ahmed Mitchel, who is Deputy Director of CARE National. Assalamu alaikum.
Wa alaikum assalam wa rahmatullahi wa barakatuh, Imam. How are you?
Thank you for asking. Welcome to Muslim Network TV. Are you happy about the dismissal of this conviction of Muhammad Aziz and late Khalil Islam from the murder for which they already served time of Malcolm X, rahimahullah alayh?
Bismillah, alhamdulillah, wassalatu wassalamu ala rasulullah. Imam, I don't think I'm happy, but alhamdulillah, it is a good development, not only because their names have officially been cleared in the court of record, but also because I think it gets us a step closer to officially finding out who really killed Malcolm X, Al-Hajj Malik Shahabaz, and who helped enable the assassination. Because if these two men didn't do it, and they didn't, it raises the question, well, who did? Who was the shooter? Who fired that shotgun? And what role did law enforcement play in potentially enabling this assassination? So I'm alhamdulillah, relieved that this step has been taken. It took far too long. This is a great injustice that law enforcement perpetrated, not only against Malcolm X, but against other brothers. And I'm glad their names have been cleared. But the next thing law enforcement needs to address is who else was involved. And also they need to specifically address the issue of NYPD officer Raymond Wood. This is a police officer who died. He passed away, but on his deathbed, he wrote a confession saying that he had specifically, in coordination with the NYPD and the FBI, arrested two of Malcolm X's bodyguards, entrapped them on a terrorism plot for the specific purpose of making sure they would not be protecting Malcolm X in that ballroom on the day of his assassination. This is what an NYPD officer said in a deathbed confession, a letter that was released earlier this year. And so that needs to be investigated. Did law enforcement deliberately enable the killing of Malcolm X? That's the next thing we need to have an answer to.
What else we learn from this case police and FBI has done wrong?
Well, what we learned is that the two men who were convicted wrongly of killing Brother Malcolm X, that this wasn't an accident. You know, sometimes the legal system, prosecutors, cops, they just screw up. They make a mistake, negligence. It's not malice. In this case, though, it was deliberate, is what the Manhattan DA is saying, that the law enforcement, the FBI deliberately withheld exonerating information, deliberately let these two men take the fall, deliberately concealed information that might have set them free. And so that's the other thing we learned, is that this wasn't just an accident. This was a purposeful violation of the civil rights of these men. May Allah grant them justice.
Do you think there is a possibility for the person who is still alive, Brother Aziz, to seek some compensation for all the loss of his time?
I hope so. I mean, normally it's very difficult to sue, for example, a prosecuting attorney because of immunity and all sorts of things in various states. However, if prosecutors and police deliberately plot to wrongfully convict someone, deliberately conceal evidence, that is a violation of their civil rights, of the victim's civil rights. And there are opportunities to file lawsuits against the state, against the city, to seek damages. So he would have to, of course, talk to an attorney, but usually that would be a possibility in many jurisdictions.
You know, you're in Atlanta and you have this Ahmed Arbery case there. One of the things which is coming out of different cases is funny stuff. A lawyer says, defense lawyer, that, there should not be many black pastors in the courtroom. What is with Georgia black pastors? So they continue to intimidate people.
Well, I think that was one of the oddest things I've ever seen in a trial. I'm not surprised that attorney might have been thinking that internally, but for him to say out loud, we don't want any more black pastors here, was a remarkable moment. And it shows you exactly what we're dealing with. That is the attorney for one of the men accused of committing this crime. And so it's telling. It says something about the environment there in that county, that this attorney felt comfortable saying that out loud, saying it in a court of law, saying it knowing that national television was broadcasting that trial. His argument was that the presence of prominent black pastors like Al Sharpton and Jesse Jackson and others would influence the jury. But his comment went beyond that. His comment didn't just say, we don't want famous pastors in here. His comment was, we don't want any more black pastors in here, singling out people because of their race. So it was an insane moment. And thankfully, the judge in this case in Georgia seems to be much more level-headed, I would say, than judges in other jurisdictions and another trial that I won't name. And he called those comments reprehensible and denied the attorney's request.
Yeah, judges, I mean, is there a method of keeping an eye on judges themselves? I know for lawyers, there could be a process, but in Rittenhouse case, judge was making insensitive Asian jokes about his lunch. And while he's trying to keep everybody in order, who's going to keep him in order?
Look, judges, when they've been on the bench for a long time, some of them stay humble. They stay down to earth. They are respectful. Some judges, sadly, develop what I would call a dictatorial type of personality. They are accustomed to ruling their courtroom like a kingdom. They lose touch with the common people. They lose touch with modern culture. And it shows on the bench and how they talk to people and the jokes they make. And that's sad. And it's frightening when you're trying to have a murder trial that is deadly serious. So there are ways to hold judges accountable. In Georgia, we have a judicial qualifications commission that can investigate and remove judges if they breach certain ethical or legal duties. In the case of Wisconsin, what the judge said that would not qualify, most likely. Furthermore, if judges show they are biased, very clearly biased, an attorney can make a motion to have that judge removed. But the judge himself gets to decide whether or not he should be recused. And then, of course, they can appeal to a higher judge. It's rare it happens, but that is a possibility. So either an investigation by the relevant judicial counsel if a judge violates the law or ethics, or in court, attorney can make a motion for that judge to be recused and see what happens. Those are usually the two ways you would get rid of a judge who's causing a problem.
Brother Edward, in Rittenhouse case, as well as the Arbery case, the defense is self-defense. How this self-defense becoming so prominent type of defense here, and how does it compare with what they call it, stand your ground?
So self-defense is definitely a part of the law. It's a reasonable part of the law, and people should be able to make use of self-defense as a legal theory when it is appropriate. If someone were to, may Allah forbid, break into my house with intent to do me and my family bodily harm, and I shoot them, that is the very definition of self-defense. But that's different than if a person goes out of their home with a gun, starts pointing at people in public, and then someone tries to disarm the armed man, and then the armed man shoots them. That is a different circumstance because the armed person provoked the incident. The armed person engaged in unlawful behavior, and therefore the other people around him had a legal right to try to disarm him. And so when you look at the Wisconsin situation, it all comes down really to this question. When Kyle Rittenhouse shot Rosenbaum, was that a legally justified shooting? Was that self-defense, or was it murder? Because if it was murder, if he did not have the right to kill Rosenbaum, then that means that after that moment, everyone who tried to disarm Kyle Rittenhouse had the right to do so because Kyle Rittenhouse had just committed a crime, and therefore the other people around him had the right to try to subdue him. And so that's why Rosenbaum, that first shooting victim, is so critical, because if that was not self-defense, then nothing else really was self-defense. On the other hand, if Rosenbaum, really was a threat to Kyle Rittenhouse's life, was a threat to his, was going to cause him serious bodily harm, then it was a justified shooting. But of course, the issue is, did Kyle Rittenhouse start all this by having that gun? Did he point it at someone? Did he point it at the crowd? And did that trigger Rosenbaum's behavior? That's what the jury is going to have to decide. Now, in Georgia with the Ahmed Arbery thing, it's different, but somewhat similar insofar as you've got the McMichaels who are chasing Ahmed Arbery down, And the prosecution is arguing they had no right to chase him down. They had no right to try to detain him. And therefore, when Ahmed Arbery, ended up in a hand-on-hand fight with the McMichael who had the gun, Ahmed Arbery had the right to defend himself. Ahmed Arbery had the right to try to fight this man, to get past him and get away. And the man did not have the right to shoot Ahmed Arbery because the man, the McMichaels, had wrongly started the encounter. So the self-defense argument, I believe, does not work in the Arbery situation. Absolutely not. No question. In the Rittenhouse thing, it's a bit of a closer question.
Okay, so what's the difference between this and stand your ground law?
Right. So stand your ground laws essentially mean that if someone is threatening you, if you feel you're in danger, you don't have to retreat. So, for example, in some states, if I'm on the street and someone, let's say at the end of the block says, "Hey, you, Edward Mitchell, I know you, I'm going to kill you," and they take out a knife and they're all the way at the end of the block. Now, I've got time to get in my car and drive away. I've got time to get in my house and lock the door. Stand your ground law means I don't have to run away. I can stand right there on the street. I've got the right to be there on the sidewalk. I don't have to run away. I can stand right there, watch that man come up to me with a knife, and I don't have to run away. And then if I've got a gun on me, I can shoot him the moment he actually tries to cause me harm. That's a stand your ground law in a very rudimentary way, that you don't have to run away. You don't have to try to flee before defending yourself with deadly force. Whereas in most states, the law would be that if you have an opportunity to flee, to get away, you can't leave yourself in a dangerous situation and then kill someone. That is legally problematic in other states.
Tell us why, in the case in Wisconsin, Kenosha, the gun is no longer a part of the charge. I mean, the person was not from that area. He came from the nearby state. He brought a huge rifle, and he was a teenager. Why that particular charge is dropped?
So, the judge indicated that he was dropping that charge because the description of the type of gun that counts as a dangerous weapon under Wisconsin law, he thought was too vague and may not apply to the gun that Kyle Rittenhouse is carrying. Something about the length of the barrel, a short barrel gun versus a long barrel gun. Again, I don't practice Wisconsin law, but that was the judge's argument. I will say that for the average person, obviously looking at that charge, carrying a dangerous weapon while under the age of 18, your average person would say, well, look, if an AR-15 rifle isn't a dangerous weapon, what is? But again, the exact text of the law matters. And so that is what had to be considered in court. The judge decided to cut him a break and drop that charge. That is the charge that I think he was most likely to be convicted on of all the charges. And so the judge gave him, I think, a great benefit in dropping that charge.
Well, thank you so much, Brother Edward Mitchell, for your time. Truly appreciate that. Assalamu alaikum.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Thank you, Imam.